Well, hello, everybody. Welcome to this Level Up Consulting Partners and Potomac Law Group Insight session. My name is Dave Cohen. I'm a director here at Level Up Consulting Partners. Very much appreciate those of you that are listening live, taking a few minutes out of your day today. And I think we're going to have an interesting conversation for you. So we're here to talk about data processing agreements. And we want to discuss kind of what they are, what some of the key elements of a good data processing agreement is, and some of the potential challenges or roadblocks you might encounter if you're using these as part of your privacy program. And every privacy program is using these extensively with vendors that they work with. So that's what we're here to talk about today. We're excited to get into that. And so with us today is a friend and somebody that I've worked with many times over the years. Heidi Salo is currently a partner at Potomac Law Group, but prior to that, Heidi's held a number of interesting posts for a bunch of different companies. So welcome, Heidi, and can you tell us a little bit about your background?
Sure. I'll keep it quick. So as you said, I'm currently at Potomac Law Group. I've been at Potomac Law since February of last year. And prior to that, I've spent most of my career either in law firms or in in-house counsel positions. So most recently, I was the chief privacy officer of Leidos, which is a $13 billion-ish company in the DC area, based in the DC area. Before that, I was in a similar role at Thomson Reuters. Before that, I was at DLA Piper, big law firm. And before that, I was at Sprint Nextel. So I could go back even further, but I won't embarrass myself. So like I said, I've spent most of my career either in-house or in law firms. And I am a lawyer. And I've been doing privacy and cybersecurity work for, over 20 years. Yeah.
Yeah. Wow. So needless to say, Heidi, from both the internal corporate perspective and as external counsel, you've had a lot of experience with these contracts and seen them in a number of different forms. So for those of those folks out in the audience that are kind of new to privacy or new to the privacy program and really kind of tuned in today to kind of get an idea of what these contracts are, how they're used, let's start with just some of the basics, definitions. What is a data processing agreement? What are the elements and kind of the basic structure?
Sure. So for those of you that don't know, a DPA is basically a legally binding agreement between two parties, of course. And you would use a DPA when you're hiring or engaging someone. Actually, you could be on the other side of the transaction. You could either be doing the engaging or you could be the entity that's getting engaged to do the work. But it involves processing of personal information or personal data, depending on which law applies. So you wouldn't use a DPA, for example, if you're dealing with widgets, that have nothing to do with individuals or identifying people. You always would use it for personal information or personal data processing. And the reason you would use a DPA is, number one, it's sometimes legally required. So for example, under the European Union and UK General Data Protection Regulation, or GDPR, you actually have to. There are other privacy laws that don't actually mandate that you use a DPA. So for example, California has a privacy law that doesn't necessarily explicitly require it, but it sort of does, because there are provisions in the California law about service providers and contractors that process personal information. So regardless of whether the words, data processing agreement are found in the law, if you are engaging or hiring a third party, like a service provider, to process personal information on your behalf, you're going to want a document, a contract that looks like a DPA for the most part.
Heidi, just jumping in quickly, regardless of whether it's required by a law that you are caught in the scope of, suffice to say, just a good idea to have a contract regarding the processing of the personal information that you're collecting, so let's say, from your customers and managing so that you're a good steward of that data.
Absolutely. Because one of the key reasons, there are multiple reasons for having a DPA. And by the way, when we talk about DPA, when I refer to it here, if that's like sort of too much, and we're going to get to that in a little bit, based on the nature of the transaction or the parties and that kind of thing, at a minimum, you're going to want to have data protection and privacy and data security provisions in your main agreement. That's sort of, to me, bare minimum. Ideal situation, and again, especially if it's required by law, of course, you would have a separate agreement that's called a DPA that would be attached to your master services agreement or SaaS agreement or whatever it might be. But you just touched on something, Dave, which is that one of the main reasons you want to have a DPA and those types of provisions is third-party risk management, because essentially you're asking a third party or a service provider to process personal information on behalf of your organization. But at the end of the day, you're responsible for that data. Okay. Yeah. So if something goes wrong and the third party mishandles it, or if there's a data breach, there's a lot of different things that can go wrong, or fails to comply with a privacy law. It's like fails to help you respond, for example, to what are called data subject requests, which is essentially an individual asking for access to their personal information or asking to correct it or delete it, et cetera. That can all go wrong, if it's not handled properly. Yeah. So you don't want to be on the hook for that stuff, because you're kind of.
And Heidi, actually, on that note, I think you and I were talking about this when we were preparing for the program. I was in DC a couple of weeks ago at the Privacy and Security Forum. And one of the takeaway notes from the many sessions that I went to and my colleagues went to was that regulators today are increasingly holding, to use the GDPR language, the controller responsible for missteps taken by processors that they've subcontracted it out to. So whereas in the past, maybe there was a little bit of shuffling of liability or responsibility between the data processor that's contracted out to by the controller, increasingly regulators are looking to the controllers to take that responsibility, elevating the importance of the DPA. Would you say that's fair?
Yeah, I mean, to be clear, it's a shared responsibility. So what I'm saying, I'm not suggesting that both parties don't have a responsibility, but I think what we've seen, as you just touched on, is in the last, let's say 10 to 15 years-ish, we're seeing a lot of what I call, or what anybody calls, supply chain risk, right? So, even if you just look at data breaches as an example, many times a data breach is happening downstream. So it's a service provider, third party, et cetera, that's suffering the breach, but they're processing data on behalf of another entity. And at the end of the day, that initial entity that hired the service provider is not off the hook just because the breach. So that's another reason. Again, it's one of the main reasons to have a DPA, or at least robust privacy and data security language in your master agreement if a DPA is just off the table. And again, we can talk about why that would be.
Fantastic. So that's really helpful. So we've kind of set a foundation, what is a DPA, in what situations are they used? Heidi, one of the things that comes up for anybody that's dealt with these even a little bit, one of the things that commonly comes up is if, let's say you're in the position of being the entity that, again, using the GDPR language would be considered the controller, collecting the information and then looking to outsource that to a third party. You probably have a template or some structure of a DPA that you would choose to use, that you would choose to pass down and have signed by this entity that you're outsourcing to. It's also likely that if they are in the business of processing for a number of different clients, they probably have their own version or their own template. So what happens in these situations, and how does it get decided which version of the contract typically gets used, or what are the factors or variables involved there?
Yeah, that's a really good question. And I know this is a common issue, right? So there are some variables, right, that will impact, which party's paper it should be on, right? So what the first thing to do is really honestly look at which one is kind of, which DPI, if you're looking at two, you're aware of the other party's paper and you're obviously what your paper says. You're going to look at which one's more comprehensive, which one better protects my organization. Okay, so in a vacuum, I'm either the service provider or I'm the controller, like you said, or if you're looking at CCPA for the California law, the business, right? Whatever you're called. First thing is, which one best protects my interest? That's a kind of a high level, quick review. Which one looks better? Because often they can be one-sided. They can be slanted, right, in one direction or another. Second, you want to also think about how much time and negotiation you personally are going to have to put in, right? There's this whole ROI thing, right? So let's just say it's a small transaction, it's not worth that much. Maybe it's, $10,000, which is not a lot for most organizations. Let's say it's a 3-year term, $10,000, right?
Right.
You're in-house counsel, if it's going to take you, 4 weeks to negotiate that thing, maybe not worth it, just based on the value of the transaction. And also it's going to be a lot harder to push your terms if, let's say, again, you're the controller, right? The service provider is not necessarily going to want to put up their own resources for what's a very small transaction, small amount of revenue on their end. So there's always an ROI on both sides. You also want to think about how important is this to your colleagues? Like, let's say this is a deal that or services that are very important to like your HR function or marketing or business development, and they're pushing, for this deal to be signed. You may in that situation say, you know what, I'd rather use our paper, but it's not worth the hassle to, push for that. Another thing to look at, of course, is the size of the party. So are we talking about negotiating on the other side of the table from Google or Microsoft?
Yeah.
You're, a small shop. We could talk about that a little bit more, but it's kind of fairly unlikely that you're going to make much, headway if you're small and they're big. And it's sad to say, but true. That's just the reality.
Yeah, and you and I were talking about this earlier too, Heidi, that and it's a very common thing. We see this all the time. People are feeling a little bit frustrated because they're even a large business trying to negotiate with AWS or Google. Obviously, there's not going to be a tremendous amount of leverage there that you have as the controller when you're outsourcing to one of these large entities. And we even talked about how if you think about it from their side, it would be challenging and difficult for them to customize these DPA documents for the thousands and thousands of clients that they basically do business with. So
exactly. And so I do understand, I guess, why often it's, again, with the bigger companies, the DPA is on their paper, to your point, because they've got a lot of volume to deal with. And as we talked about earlier, often like Microsoft, for example, posts its data protection terms and conditions online. So it makes it even less likely that they're going to negotiate, because they'll just point you to that URL, the website, and say, here they are. There are exceptions to the rule. There are cases where, you may be able to get a Microsoft, I'm not picking on Microsoft, that's just an example, to, find a lawyer in the legal department that will actually negotiate with you. But again, that, in my experience, that tends to be the exception to the rule.
And then speaking of those negotiations, Heidi, how common is it for there to be, a fair number of iterations and back and forth in terms of, redlining of these documents? Is that fairly common, or are a lot of these documents relatively straightforward and have been used a number of times and they can move a little quickly? And as a kind of an addition to that question, if you may, if someone who's listening into this program is not an attorney, but they work in a privacy program and they're responsible for managing these contracts, wondering a little bit, since you've held the role of internal counsel, those contracts, I would assume, get shuffled over to internal legal for review, and then they come back. Can you talk a little bit about how that process typically works?
Sure. So to answer the first part of your question, again, it's sort of it depends, right? So obviously, if it's a take it or leave it situation, the terms are posted online. It's like either sign them or agree to them or not. Obviously, there's no negotiation. So that's may not protect your organization the way that you want it to, but but that's pretty straightforward. If it is sort of like equal bargaining power between the parties and that kind of thing, what I have found is it's actually surprising how much time it can take to negotiate a DPA. People that are not in the privacy field, I think, and again, not bashing anyone, I'm just saying factually, don't always understand that it can get pretty protracted. Mm-hmm. So what I have found in my experience is that often, like, other parts of the deal, like, again, the master services agreement or whatever, all of that might get hammered out, and not take super long, but then the DPA is where you get really stuck. And the provisions that tend to be, heavily negotiated are things like limitation of liability, so again, the data controller or the business typically is going to want the service provider or the data processor to agree to, either no cap, for data breaches and violations of privacy laws, or they're going to want kind of like a big liability cap, so to speak, right? And of course, the service provider or processor wants the opposite. So that tends to be, limitation of liability tends to get heavily negotiated. Audit rights, so the right of the controller or the business to audit the service provider, that tends to get heavily negotiated, not only in terms of whether they have audit rights, but also, reasonableness. Like, can you just show up at our premises anytime, or, no, you have to give us notice and it can't be more than once a year, things like that. That tends to get negotiated. Indemnification tends to get heavily negotiated. Data breach notification. I think that's becoming a little more streamlined now, but, for years that was a big deal because, again, the controller or business typically wants to be notified ASAP, right? Within 24 to 48 hours. And it's the opposite for the service provider because they want the time to be able to investigate and figure out what happened.
Right.
I'm trying to think what other the big ones are. Even definitions. I mean, I've had situations where even defining, what is personal information or personal data that's in scope of the agreement, even that can get negotiated, believe it or not. So sometimes, yes, it does get protracted.
So a couple of important takeaways that I'm hearing, Heidi, are, as you were stating earlier, factors to consider whether you want to or need to get into a protracted conversation and negotiation in creating these contracts have to do with the size of the deal, the value, the volume of personal information, and maybe the sensitivity of that personal information that's going to be processed. And let's not forget, there are business pressures and tensions. So this is a vendor that we really need to onboard quickly. You're getting, if you're sitting in the privacy office, you may be getting pressure from the business end in terms of you're holding us up. We need to get this done. So there's that pressure there. However, oftentimes folks in the privacy office feel like they need to be able to communicate that, yes, we understand that, and we do want to, hopefully work with this vendor. However, there's probably some, at times, I would imagine, some education that needs to take place about the liability to the company should we rush this contract or say we'll just take on too much risk here, because people aren't aware. They need to have a little bit of understanding from the business side about the risks involved in terms of complying with these laws, which keep popping up and proliferating, right? So I imagine there's back and forth there internally as well.
Yeah, absolutely. And you touched on a really interesting point, which is that when I say the size of the deal is relevant, it is in terms of trying to figure out, again, as the person negotiating, what's my ROI, right? Or which paper, should it be on our paper or the other party's paper? But what's also really important, as you just touched on, is that there's not necessarily a direct correlation, though, between the size of the deal and the risk. Right. You can have, a small, $10,000 transaction, right? But if there's a ton of, sensitive
personal social security numbers
or special category data under EU GDPR or whatever, the risk is the same. Like it's there. That's where there's not a correlation. So to your point, Dave, that's a great point. I have found that often your colleagues that aren't on the front lines negotiating these agreements maybe don't, necessarily appreciate the risk to the company. And the fact that, again, there's not that direct correlation between the size of the deal and the risk. So again, really, really good point there.
Yeah. So we've, probably got about a little less than 10 minutes left here. So this is a great time. If you're out there in the audience, you're listening, you have some questions, please feel free to send them in. We'll see if we can take a few of those before we wrap up here. But while we're seeing if we get any questions in from the audience, Heidi, a DPA is not always necessarily the right route to go in terms of contracts. There are alternatives in certain situations. Do you want to talk a little bit to the audience about what some of those alternatives might be, and in what situations they might be a better choice?
Sure. When we say alternatives, again, we're talking about if processing of personal information or personal data is involved, right? So we're not talking about, just to be clear, we're not talking about a different type of agreement. But there are alternatives. Without getting into too much in the weeds on data transfer restrictions, which is probably a whole other topic we could cover, Dave.
Yeah, another session maybe.
Yeah, another session. Again, you may already know this, the audience may know this, but or you know this, but there are these legal restrictions essentially if you are transferring personal data or accessing personal data from certain jurisdictions like the European Union or the UK, and you're accessing or transferring that data in a jurisdiction that doesn't have quote unquote adequate data protection laws on the books. Again, this is a whole other topic.
Yeah.
So there are some alternatives if you need to put in place data transfer contract provisions. So that's what I'm going to start by saying.
Yeah.
So there's something called binding corporate rules, which essentially is, a very lengthy set of documents where you're binding your company and all the affiliates to comply with the applicable data protection laws. And the purpose, if you think about it, is to make sure that as personal data flows around the world, whoever is accessing it, processing it, no matter where they are, they're still going to follow the same rules with respect to processing. So that's kind of a specific thing for data transfers. Another specific type of agreement with respect to data transfers would be like the UK International Data Transfer Agreement. Again, totally different topic, another day to talk about that.
Yeah.
You could also ask if your service providers comply or are certified with codes of conduct, which, are these like schemes basically that a service provider can attest that they comply with, and they can be, they can get certification and that type of thing. So that's another alternate, another route. Just to, if nothing else, it gives you more of a comfort level with respect to your service provider. There are data sharing agreements that you can put in place. Again, not necessarily a DPA, it's more of a DSA or data sharing agreement. And then, as I mentioned earlier, if a DPA is really not feasible, because, again, the GDPR maybe doesn't apply, so it's really hard to convince the other side that, yeah, we need to sign this separate, DPA.
Yeah.
At a minimum, you want to make sure that your master agreement has good language in it around data protection, privacy, data security, indemnification, limitation of liability, all the things we've talked about.
Right.
Yeah.
Right. So the things that we've been talking about that are, maybe typically found in a contract known as a data processing agreement can also sometimes be woven into the master service agreement, which may be an efficient way. And obviously there's pros and cons of that approach for organizations. Well, that's fantastic. Looking to see if we have any questions. We don't have any questions in at the moment. So I think with that, let's just take us to a close. Heidi, with the kind of a final thought about how obviously these are not static things. They're reviewed, they're edited. Hopefully a good meeting place is found in the contract between the two parties in a reasonable amount of time, and then signed. But clearly they need to be reviewed with laws coming through, and there should be a cycle of review. Do people typically tend to review these kind of on the fly, like monthly or twice a year or annually? Is there any kind of a sense we can give the audience there, or does that vary?
So do you mean like after it's been signed, like how often?
Yeah, after it's been signed and put into place. Is it typical for an annual review? Is that frequent enough, or is more frequent a good idea, especially given the proliferation of new state privacy laws, for instance, and different jurisdictional requirements. Yeah.
I mean, that's a great question too. Well, part of it will depend on what is the renewal term, right, in the agreement. So, for example, if it's like an annual renewal, then obviously before that date comes up every year, you're going to want to look at it.
Right.
And actually, if you want to have flexibility and be able to amend it, that's helpful, because that's like every year you're given that opportunity essentially.
Yeah.
To
it's advantageous, right?
If it's a longer term agreement, like a 3-year agreement or 5-year, it's a little more challenging, because I mean, you could review it once a year and see if anything's changed that needs to be, if any laws or whatever have changed that might need to be addressed in the agreement. But it might be harder for you to convince the other side to reopen, the agreement, because from their perspective, it's signed and it's a 5-year term or whatever it is.
Yeah.
So part of that will depend on that.
That makes sense.
Yeah, but that being said, it's always good. What I always try to make sure of, and I'm sure others do as well, is, you want to always have, in addition to sort of the specific data protection and data security provisions that we've talked about, you want to also make sure that you've got sort of that generic compliance with all applicable laws. Again, if you're the business or the controller, that's, you know what I mean? Because that's like a fallback no matter what. So like if the law gets amended, if some law does get amended or whatever, you've got that generic, either the service provider or both parties must comply with all applicable laws.
So don't forget that phrase. That's a great point, Heidi. Just that kind of overall kind of liability clause and indemnification. Yeah, that's terrific. So all right. Well, terrific. So thanks so much for your sharing of experience with these contracts and a very important topic, kind of the core and the backbone of a lot of privacy programs. So we hope that those of you that joined us either live or listening to this as a recording got some good takeaway information if you're dealing with these types of contracts. So Heidi, thank you so much for making some time for us today and joining us on the program. And as you mentioned, it would be great to do some follow-up sessions. We have lots to talk about on related topics. So very much appreciate you spending some time with us today, Heidi. Thank you so much.
Thank you so much, Dave. It's always a pleasure to catch up with you. Thank you so much.
Okay, great. And then we also, I think we're going to put, we did get a question. So let's go ahead.
I just saw that pop up. Yeah.
So let me read this out loud and then we'll tackle it. Are the great majority of DPAs you encounter out in the market, quote unquote, legally adequate, such that they check all the boxes for provisions that are legally required or important? Or do you find that a great number are deficient and require revision negotiation? That's an interesting question. Just in your experience with
that's a really good question too. And I hate to give a lawyer answer, but the answer is it depends, because what I have found, again, in my career, just going kind of back and forth between being in law firms and representing clients and then working for companies. So like in my current role at PLG, Potomac Law, I work with companies of all different sizes and all different maturity, if that makes sense. Like, so I work with startups, I work with the, medium-sized companies that are a little more established, and I work with big, Fortune 100 companies. So what I have found, I wouldn't say the majority, I would hesitate to use the word majority or most, but I definitely found that the more, and I'll use the word mature, a company is, the bigger a company is, the longer it's been around, the more likely you're going to see a DPA template that still probably, they can always use improvement. They can always use tweaking, all of that. There's always room for improvement, I think, but they tend to be much more robust. Whereas I've worked with a lot of, smaller companies or startups that, don't have a privacy office. They frankly just don't even have lawyers or anyone focused on this stuff. And so for those entities, or I also work with nonprofits. That's another example. They may not have anything. So they're literally starting from scratch. So I hope I'm answering the question there, but it really does. It's kind of all over the map.
Well, yeah, but that makes sense. So, but in general, what I'm hearing is The bigger and more established a company has probably been reviewed a number of times, iterated, improved, tweaked.
Yes.
So fair enough to say, at least as a starting point, likely to be more comprehensive than a newer agreement that's been put together by somebody who's doing this for the very first time. And I'm sure that after you've reviewed, tens and hundreds of these, that you start to be looking for particular things, and they kind of pop out, or that kind of a glaring omission or something that might want to get updated. So yeah, hopefully that is helpful for the person who asked the question.
Definitely.
Great. And I think we're going to put, if you're trying to if you'd like to get in touch with either of us after the program, we'll provide a little bit of contact information there. And you can reach Heidi at the Potomac Law Group, and you can reach myself at Level Up Consulting Partners. We'd love to continue the conversation with you if you have any follow-on questions. And once again, Heidi, always a pleasure. Really appreciate making some time, and I hope you have a great rest of your week and a great upcoming weekend.
You too. Thank you so much. Really appreciate it.
And thanks to all of you out in the audience for tuning in. We